Welcome back to educator.com. Today we're going to go over the National Judiciary. So let's get right down to the material here. In today's lesson overview, we are going to differentiate between original and appellate jurisdiction. It's good to know. We're going to describe the structure of the National Judiciary. We're going to explain the process of judicial selection and also senatorial courtesy, when that applies and when it wouldn't apply. And then we're going to identify the informal requirements to become a Supreme Court justice. And right now, as of the time of the filming, obviously, we're going to examine the current makeup of the Supreme Court of the United States. We're also going to review how the Supreme Court operates. And then this is where a little history once in a while might appear on the AP exam. We're going to briefly identify the court decisions associated with the Warren and Burger courts. So again, very little is required to know. So the little that you have to know, we are going to review. All right, so the federal court system. In the United States, you have the federal court system, and then you have the state, just like in a lot of different areas of federalism. Just like you have state senators and you have U.S. senators, you also have state courts and you have federal courts. So our main objective, or our objective in studying the judiciary, is only from the national perspective rather than state courts, which generally deal with criminal cases. Although again, federal courts will deal with those issues as well. But again, there's a separate court structure that's established for both. So what is jurisdiction? Jurisdiction is the authority of the courts to hear certain cases. So federal courts have jurisdiction in cases involving federal law, treaties, and interpretation of the Constitution. So that's where the federal courts will dictate and rule on cases accordingly. Now, there's three types of jurisdiction, so to speak. There's original jurisdiction, appellate jurisdiction, and concurrent jurisdiction. So original jurisdiction, that really has to do with lower courts having the authority to hear cases for the first time in the federal system. Again, rarely does the Supreme Court have original jurisdiction. A lot of the district courts will have original jurisdiction, but rarely will the Supreme Court listen to a court case for the first time. Now, they do have that authority, for example, if it's between a foreign government, but rarely are they going to exercise an authority dealing with original jurisdiction. Appellate jurisdiction, on the other hand, that's when the courts hear reviews or appeals from the lower courts. Now again, the Court of Appeals, for obvious reasons, they have appellate jurisdiction, so appeals. They're gonna hear court cases when they get appealed from the district. And again, the Supreme Court, they also have appellate jurisdiction, and pretty much the vast majority of their cases are going to be heard on appeals. And then there's also concurrent jurisdiction, which simply means that the courts share jurisdiction with state courts. Now, in cases where there's conflict, there's going to be more weight given to the federal authority. So that's generally the rule of thumb when things have concurrent jurisdiction. So the structure of the judicial system, or at least the National Judiciary, again, you have the district courts, you have the Court of Appeals, and then finally you have the Supreme Court. So again, knowing about the Supreme Court is probably going to be the most useful for this exam, but do know that district courts and Court of Appeals, they do exist, and some brief facts regarding that. So district courts, what do you have with district courts? Every state has at least one district court, and there's 94 in total. So I can imagine larger states have multiple district courts, and these courts have original jurisdiction and decide civil and criminal cases under the Constitution. So there's, all these district courts, and that's where a lot of the Supreme Court justices, they start off. They start off as district court, and then they move on to the appellate court. And then usually the president is going to select a Supreme Court justice who has experience in that. And that's not the only route to the Supreme Court, but it's kind of a natural rising up the ranks of the district and the appellate court system. Now, the Court of Appeals, again, it's generally a lot more high profile. 13 courts with states divided into circuits, which include D.C. and Puerto Rico. And again, a panel of judges, they hear cases on appeal and they decide on whether or not they agree with the district courts, or if they disagree and they overturn certain decisions. Now, at that point, if it goes higher than the Court of Appeals, then you go to the highest court in the land, which is obviously the Supreme Court of the United States of America. And again, this is the only created court under the Constitution. So the other courts are created as a law created by Congress. It's nowhere in the Constitution does it specify this many district courts or Court of Appeals. So the Supreme Court is the only court that's established, and currently we have 9. But again, even that 9 number is not strictly dictated in the Constitution. So the Supreme Court is the final authority with most cases on appellate jurisdiction. And again, they're not going to hear every single case. In fact, the vast majority go unheard, simply because of the numbers. It does, with all the court cases that are appealed, the Supreme Court, they're only going to choose a handful. I think if you had to throw a percentage out there, it would be, under 5%. So, again, a multiple choice question, what is the amount, rough percentage that Supreme Court, they're going to hear cases on appeal? It's going to be less than 5% of the court cases that are on appeals. So judicial selection, how does that work? There is no formal qualifications for federal judges. So in fact, I know it sounds ridiculous, but if President Obama appointed a 2-year-old to the Supreme Court, technically, there's nothing unconstitutional about that. Now again, with the ridiculous nature of that appointment, the 2-year-old is more than likely not going to get appointed or confirmed by the Senate. Or let's say a slightly less ridiculous example: can a Supreme Court individual, does he or she have to be a citizen of the United States? Can it be a permanent resident? Again, there's nothing that's required by the Constitution, but again, if you're a permanent resident, chances are you are not going to be offered that post. Now, can you be a naturalized citizen? Absolutely. I don't think there'd be any issue. But again, it's most qualifications that Supreme Court justices or federal justices are going to have, they're informal rather than formal in nature. And another good thing, especially if you're a justice, is that you serve during good behavior, which basically means for life in practice, unless you do something really bad, in which case then you have the same process of removal as the president. So again, life terms exist so that judges are free from political pressures when deciding a case. So the president can appoint, but they cannot fire justices. Justices retain their judicial independence. But they can be removed, again, similar to the president, through impeachment and conviction. Again, very rare for this to happen, but again, this is a process that is out there to remove justices when they do not abide by good behavior. The president would consult with senators and his party prior to making district court appointments. With the 94 district courts out there, the senator is going to be advised upon, so there will be maybe a list of acceptable candidates that the White House office generates, and they give the senator, it's going to be of the same party. They're not going to really consult. So the senatorial courtesy only extends to the same political party. But again, this practice of senatorial courtesy is going to apply only for district courts and not Court of Appeals, simply because there's only 13 Court of Appeals positions out there, and so that's really too high profile for the senator to actually make. And even the idea of senatorial courtesy, one of the criticisms of that is that it's reversing the process of what the founders wanted, where the president appoints and the Senate is the one that confirms. Basically, what ends up happening is kind of a reverse role where the senator is actually kind of doing the picking and the president is okay with that. But again, it's an informal custom, and it's something that is, again, informal in nature. So it's something, it's a practice that not many people really object to, particularly because it only really applies with the district courts and not the Court of Appeals, and certainly not the Supreme Court. That's the president's call. Again, it's very difficult for the White House office to keep track of all the qualified candidates. So again, if anything, this is a way of kind of managing the workload for the White House staff. Basically allowing the home state senator, who probably has more knowledge on the ability of the talent of the justices in the area. So, if anything, the idea is that the vetting process is actually delegated to the senators rather than the president. So the Court of Appeals, again, too high profile for senatorial courtesy to be used. It's only found in the district courts. So the Supreme Court, this is the top position. Now, what are the factors that are made in Supreme Court selection? Well, again, this is a huge issue, particularly with elections. You can make the argument that the power to appoint Supreme Court justices is possibly the biggest power given to the executive, simply because a president serves 4 years, maybe 8 years. Supreme Court justice, if that justice is young enough, can serve 40 years or 50 years. So it's definitely within the realm of possibility. So that power to appoint Supreme Court justices is usually a key component on why an individual might vote for a particular candidate for the president. And again, even if that's not the only thing, in practical terms, that's a real power that the president has. And so in choosing, there's a lot of different factors. And so, 4 different factors that I chose out, that I chose, again, it really is a combination of a lot of factors, and again, maybe some factors that we're unaware of because we're not the ones making the choice. But it has to do with party affiliation, race, gender, religion, region, judicial experience, and graduated from big name school. Again, that's really not something that the president throws out there, but it's kind of interesting if you kind of look at the makeup of the current Supreme Court. Party affiliation, that's definitely a key. Now, judges, they try to be politically neutral, but if that's the case, it's very coincidental that when a president appoints a Supreme Court justice, usually they're of the same political party or same political ideology. So very rarely will the president, who is conservative, appoint a liberal. Now, it is possible that a conservative president or maybe a moderate president, a moderate Republican, might appoint another moderate Republican or a seemingly conservative. But the Supreme Court justice is not bound to operate under what the president thinks he or she is going to decide. So once you're in office as a Supreme Court justice, well, guess what? You can kind of switch your views, or basically be more liberal than you let on to be, or be more conservative. It actually has happened where a Republican president thinks he or she is appointing more of a conservative, or at least more of a conservative leaning moderate, and when in fact it's more of a liberal leaning individual. And again, vice versa, it can happen that way as well. Again, you have race, gender, religion, and region, judicial experience, and then I just threw that in there. Graduated from big name school. I did a personal breakdown of the current makeup of the Supreme Court. So party affiliation, president will select judges from his own political party. again, you'd have to find an example where this isn't the case. Now, again, judges, they try to stay politically neutral, so they're not necessarily going to trumpet what political party that they belong to. But, these judges are voters as well. And, chances are, if a Republican president is going to appoint a Supreme Court justice, chances are that Supreme Court justice usually votes Republican in the elections as well. Can't know for sure because we have the Australian ballot, but chances are they're going to have this be of the same political party and ideology. And Supreme Court justices, they basically have to pass this litmus test. Now, if presidents are asked, do Supreme Court nominees have to pass the litmus test? The politically correct thing to say is no. The president, they're going to say that I'm going to appoint someone based on their qualifications, their ability to, be a good Supreme Court justice. They don't have to pass a litmus test. But, de facto, if you're a Republican president, then there's going to be a lot of pressure to have the Supreme Court nominee be someone that is pro-life. And similarly, a liberal president, a Democrat president, is pretty much going to be in a position where the litmus test is whether or not the Supreme Court justice is pro-choice. And so, yes, there is really a litmus test that an individual must pass in order to be confirmed. So race, gender, religion, and region. Again, these factors are considered by the president prior to selection. The last two Supreme Court justices that Obama put onto the Supreme Court, or the only two, were actually women, one Hispanic woman and one woman. And so those are the only two women that are on the Supreme Court. Actually, in addition to Ruth Bader Ginsburg, another Democrat appointee. So there have been 4 women that have served on the Supreme Court, and 3 of them currently serve: Ruth Bader Ginsburg, Elena Kagan, and Sonia Sotomayor. And the first female Supreme Court justice who retired was Sandra Day O'Connor, and she was actually appointed by President Ronald Reagan. So that was a landmark feat within the Reagan administration. And again, judicial experience. So prior judicial experience as judges in district courts, courts of appeals, state courts, or prominent attorneys. Now again, there's no formal requirements. So, the bare informal requirement is obviously to have passed the bar exam in at least one of the states to be either a practicing lawyer or Supreme Court or a justice in the state courts. But again, the very traditional path to becoming a Supreme Court justice would be, serving in district court, court of appeals, and then Supreme Court. Very few make it that far. That's as far as in the legal field, that's the major league. So you've hit it big time if you made it to Supreme Court. So that's going to be something that is a rarity. But again, if you see all the Supreme Court justices, they're going to have very extensive legal resumes that get them to the Supreme Court. And again, graduated from big name school. What's interesting is that on the current court, there's 6 justices that have graduated from Harvard Law, and the other 3 graduated from Yale Law, which I'm sure would be a great selling point for both of these schools, Harvard and Yale. And so it's not impossible for a Supreme Court justice to have graduated from a lower tiered school, but again, it hasn't happened. So, or if it hasn't happened with the current Supreme Court makeup, and generally there's not going to be a whole lot of precedent where a Supreme Court justice hasn't graduated from a top name law school. If not Yale or Harvard, then you're going to have Columbia Law or one of the Ivy League institutions. So the current Supreme Court justices, again, the AP test is not really a test of current trivia, but again, it's good to know just the idea of some of the characteristics of Supreme Court justices. The current Chief Justice is John Roberts. He was a George W. Bush appointee. He was a conservative, and he was going to be just an associate justice, but basically he was replaced as a candidate to replace William Rehnquist, who had passed away. So he died while an active Supreme Court Chief Justice. So John Roberts actually took over. So rather than appointing him as an associate justice and promoting another justice to be the Supreme Court justice, George Bush said, "Well, let's just kill two birds with one stone here," and John Roberts got the position. What's unique about John Roberts was that he was the only Supreme Court justice of the nine that had young children. So it's kind of interesting that he is conservative, but the way that he has kind of decided on a lot of cases, he's in a different position than some of the other Supreme Court justices in that he has young children. So kind of his paradigm of thinking might be slightly different. Most notably, he actually, in terms of Obamacare, he actually, went and voted it as being constitutional. So he actually disagreed with his conservatives, and he actually sided, maybe for a different reasoning, but he sided with the liberals on that case. So again, these Supreme Court justices, they have minds of their own, and they're not under any obligation to support the president. In fact, they can go completely opposite to what the president wants. Second Supreme Court justice is Antonin Scalia, known conservative. Reagan appointed him. Anthony Kennedy, again, he was another Reagan appointee. He's turned out to be a little bit more moderate than Reagan had anticipated, so to speak. So he's actually known as being the swing vote on the Supreme Court, meaning that's is a conservative leaning, but he could side with the liberals on certain cases. And again, these are just things based on observation. Obviously, Supreme Court, they might not necessarily agree to their characterizations, but in practice, that's basically how they're perceived, and perception is reality for the most part. Clarence Thomas, he was a Bush Senior appointee, and he's a conservative. Ruth Bader Ginsburg, a Clinton appointee, and very liberal in terms of her political ideology. And then you have Stephen Breyer, another Clinton appointee, liberal. And then Samuel J. Alito, who is a Bush Jr. appointee and conservative. So again, you see these presidents who are long out of office, Reagan, Bush, Clinton, Bush again, and they're showing the influence that they have beyond their 4 or 8 years as president of the United States. Now, what was kind of interesting about the Alito appointment was that Bush originally nominated an individual by the name of Harriet Miers to replace Sandra Day O'Connor. But basically, Miers lacked the proper Supreme Court credentials, and she eventually withdrew her nomination. She was actually George Bush's personal attorney, and I think she graduated more from. She didn't graduate from an Ivy League institution. So what was interesting is usually when an appointment is made, usually members of the other party question. But what really essentially killed the Harriet Miers nomination was that individuals within Bush's own party, the Republican Party, they were blasting Harriet Miers, whether fairly or not, as not having the proper conservative credentials, and basically that pick was kind of a disaster. So she pulled her nomination, and Bush appointed Samuel Alito, who's more of a known conservative, and again, he's tended to vote conservative on the Supreme Court. And then you have the two female Obama appointees. You have Sonia Sotomayor. Again, Obama appointed her, liberal. She replaced another liberal, Souter. And Elena Kagan, Obama appointed her, another liberal, and she replaced John Paul Stevens. Now, is it a coincidence that these liberal-leaning justices retired during a Democrat administration, and and they did so prior to his re-election? Probably not. I mean, same thing can be said of the Republican justices that retired during the Bush administration, because had they retired during the Obama administration, then you're going to have someone that's more liberal-leaning appointed to the bench. So there's a lot of things that go into whether or not you're going to retire or stay on based on the political ideology of the president. So the Supreme Court at work, what actually goes on? Well, thousands of cases are appealed, and yet only a few hundred are heard. So maybe, again, a rough number, 3 to 5%. So a very single-digit percentage of the court cases that are sent to the Supreme Court, only a very handful of them, really, if you think about it, is actually heard by the Supreme Court. And there are a variety of reasons. One reason could be that the justices agree with the lower court's ruling. But one thing is that the Supreme Court, they try to make clear, is that just because they don't hear it doesn't mean that they agree with the court's healing, or not the healing, the court's ruling. So by not hearing the case doesn't mean that the court actually approves. This simply means that they didn't hear it. Another reason could be that they just simply don't believe the case is significant enough. It's just not worth their time to go over. Again, there are only a finite number of cases that they can actually review per year, so they're only going to choose what they perceive to be as the most significant of the cases. Or it could be that they simply do not want to hear the case. Maybe they want to rule one way, but they realize that they have limited authority, and so if they rule, for example, Roe v. Wade, decided in 1973, made abortion legal, at least in the first trimester of a pregnancy. Well, it's probably the case with the current Supreme Court that if they ruled on a case dealing with abortion, that they could theoretically overturn abortion in the United States. But they realize that part of their legitimacy stems from the fact that they have support of the public. So if they handle or if they tackle such a controversial issue as abortion and overturn it by a slim 5-4 majority, then that might give their particular branch less credibility. So part of the reason why they might stay away from some controversial cases is that they're lacking in a unanimity. They're lacking police, or they're lacking in support from the public. So they stray away from things that can be too politically explosive. Now, how do they actually go about hearing a case? Well, there's something called the Rule of 4, where 4 of the 9 justices must agree to hear the case before it's placed on the docket. So not quite a majority. So technically 44.4% of the justices, if they agree to hear it, then they'll hear it. Now, if the Supreme Court looks at all the cases and they decide, yes, they want to hear this case, the Supreme Court, they issue what's called a writ of certiorari, directing a lower court to send up records for a review, meaning they will review the case to interpret a law and decide constitutionality. So the lower courts, they're going to request for a writ of certiorari, possibly, or the Supreme Court can just decide that, okay, we want to review this case, so they're going to send it on up. And again, it doesn't mean necessarily anything other than the Supreme Court, they're going to look at it and get the information from the lower courts. So again, when that happens, lawyers for both sides, they file a written brief providing written arguments to the justices. And it could be pretty intimidating. A lot of these lawyers, if it's the first time arguing in front of the Supreme Court, they'll present oral arguments in front of the Supreme Court. And a lot of the times, there's 9 justices, and when they're asking questions, they're really asking questions sometimes through the lawyers, just to bounce back at one of the justices. So, and a lot of the Supreme Court justices, during oral arguments, they've already made up their minds. So sometimes the oral arguments have no bearing on the decisions, and so it's a tough task for a lawyer to argue a case in front of the Supreme Court. And then sometimes interest groups are invited to submit amicus curiae briefs, known as Friends of the Court, supporting or rejecting the arguments of the case. So interest groups can get involved in Supreme Court decisions if they feel that it's going to impact them. They're going to write up briefs and provide that information to the Supreme Court as well. So majority, concurring, and dissenting opinions. So majority opinion is exactly how it sounds. So a majority would be at least a 5-4 decision. But basically the majority is what, again, the majority of the court feels. And this is when a majority of justices agree on a decision and its reasons, with the Supreme Court selecting who writes the opinion. So whoever writes the opinion, they write on behalf of the majority of the court, saying that, they believe that the case should be ruled this way because of so and so reason. So that's the majority opinion. Now, sometimes there's a concurring opinion, and what that means is that concurring opinion is that you agree with the decision, but the reasoning by which the majority came up with that decision, you disagree with. Now, justices are, there could be two different concurring opinions, but concurring opinion, again, is you agree with the outcome, but you disagree with the process by which they came out with the outcome. So a justice who agrees with the decision, but not with the reasoning, is free to write his own response. And then the third type of opinion is going to be the dissenting opinion. And again, there could be more than one dissenting opinion, but basically, this is when a justice in the minority with the most seniority will usually write an argument disagreeing with the majority. And again, especially when it's a 5-4 decision, there's going to be a huge dissent. I mean, basically, it's indicating that one person's view of the law is going to be different than another individual's view of the law. So again, just goes to show you that Supreme Court justices are human just like anyone else, and the idea that they have a lot of power. So even a 5-4 decision on a huge decision that impacts public policy, it goes one way because of a 5-4 decision. So if if the one justice kind of switched from a conservative-leaning ideology to a liberal-leaning ideology, or vice versa, it can have a tremendous impact on how laws are actually constructed. So again, that's the argument that the President of the United States has tremendous influence because of his or her ability to select a Supreme Court justice. So these courts as policymakers, so again, there's really two courts in the 20th century that you really have to be aware of, and then you have the current court with Rehnquist and Chief John Roberts, but they haven't made a whole lot of landmark decisions that you're going to see on the AP test. But the Warren Courts from 1953 and 1969, they are considered basically the most liberal court ever, especially in the area of civil rights and civil liberties. So they're the ones that decided on Brown versus Board of Education, and they specifically made it unanimous, a 9-0, where there's no dissenting opinion, that said basically segregation is inherently unequal, overturning Plessy versus Ferguson. And then you had Gideon versus Wainwright, basically giving legal representation to individuals accused of a crime, and it doesn't necessarily have to be for murder. So it gives right to counsel even when an individual can't afford it. And Miranda versus Arizona, again, it gave as a victory for those believing that the police had gained too much power. So more power was given in the sense that now criminals who are arrested, they have to be read their rights so that they know exactly that they do not have to confess to a crime. So again, the Warren Court is known as being the most liberal court of its time. With the Burger Court from 1969 to 1986, there's a little bit more shift to a more conservative court, which incidentally though, they're the court that is responsible for permitting abortion in Roe versus Wade. But again, it was a 5-4 decision. So again, it's hard to say that the Burger Court was united, because again, you have different individuals with different ideologies making up the court. But they did deny executive privilege to Nixon in U.S. versus Nixon, and they also ruled against quotas in the Bakke case. But at the same time, they upheld the legality of affirmative action. So again, there's a lot of decisions that the Burger Court and the Warren Court made. But again, for the purposes of the AP exam, when you see a question on civil rights, civil liberties, it's good to know that the Warren Court was the court responsible for the expansion of a lot of civil liberties and civil rights. And then you have the Supreme Court under the William Rehnquist and John Roberts, which is 1986 to the present. Generally speaking, again, this is just as a rule of thumb. Generally speaking, you have a conservative court with conservative decisions, and they've actually limited defendants' rights, abortion. So they haven't overturned abortion, again, partly because they only have X amount of authority. So, but they've made decisions that have restricted abortion rights, and also affirmative action. So they again, generally conservative court in a lot of these decisions, and also one notable case that they ruled on, the Roberts Court, Citizens United, which basically was a defeat for those that believed in campaign finance reform and limiting expenditures. That probably would go on as one of the more significant decisions under the John Roberts Court, in addition to the decision that upheld the legality of Obamacare. So example number 1. Under the guidelines of the Constitution, which of the following is not within the jurisdiction of federal courts? So again, 4 of these are. Which one is not? Cases involving federal law. Well, absolutely, it is part of federal jurisdiction. Cases involving territories. Again, absolutely. Cases involving interpretation of the federal Constitution. Again, another thing that is included as far as jurisdiction of federal courts. Treaties, absolutely. Cases involving interpretation of state constitutions. Okay, this is where this is not in the jurisdiction of the federal courts. So the answer is E. Example number 2. What type of jurisdiction does the Supreme Court have? Well, do they have original jurisdiction? Absolutely. Again, that's not a primary. That's not the primary thing that they do, but they do have original jurisdiction. Appellate jurisdiction, again, absolutely. Do they have concurrent jurisdiction? And again, it's not the case, because they don't share the authority with states. They're the final arbiter, so they're the final law of the land. So they're not going to have concurrent jurisdiction. So this one's easy, 1 and 2 only. So the answer is D. Again, with the emphasis being on the appellate jurisdiction. So again, the vast majority, 99% of the cases, are going to be appellate jurisdiction. Example number 3. Which of the following best describes formal qualifications for a federal judge? Which, again, if you remember, there are no formal qualifications for a judge. So anything that says that you have to be a certain age, or certain requirements, or live here, or etc., they're not formal qualifications, which, again, it could be informal, but it's not formal qualifications. They serve during good behavior. Now, that's true, but that's not the qualification that's required to become a Supreme Court justice, or a federal judge for that matter. The president appoints them with the approval of both the House of Representatives and the Senate. Again, that's not a formal qualification, and this is also wrong, because it's not the House really that confirms the nominations, it's the Senate. So on 2 counts, this is incorrect. They serve at the discretion of the president. This is incorrect. They're appointed by the president, but they serve during good behavior. So if a president regrets an appointed justice after he or she has been appointed, the president can't fire the justice. That's not a power found in the Constitution. The proper removal for a federal judge would be impeachment and then conviction. They serve at the discretion of Congress. Again, that's not true. Again, the Senate appoints, but once appointed, they serve during good behavior, so they are not serving at the discretion of the Congress. There are no formal qualifications required to be a federal judge, and that is true of district court, appellate court, and also the Supreme Court. But again, there are a lot of these informal requirements that's required to be a Supreme Court justice. Okay, example number 4. Which of the following has the least bearing when the president makes an appointment on the Supreme Court? Okay, so when a president decides the Supreme Court, again, as we saw in this lecture, you have Supreme Court justices that are still serving that Reagan appointed, and Reagan was president over 20 years ago. So you have a huge influence, possibly the longest lasting thing that a president can do is to appoint a Supreme Court justice. And which of the following has the least amount of bearing? So what does have bearing, and we'll cross that out. Party affiliation, absolutely. So that is incorrect. Republican is going to want to appoint a Republican president, and vice versa. A Democrat's going to appoint a Democratic nominee, or again, liberal, and then conservatives. Judicial philosophy, absolutely. They're going to take into account whether or not the justice is going to have more of an activist approach or more of a approach that has more restraint. Educational background, absolutely. If you didn't go to Harvard or you didn't go to Yale, the odds are stacked against you that you're going to become a Supreme Court justice. Judicial experience, absolutely. That has huge bearing. Again, that kind of explains Harriet Miers's rejection. She didn't serve on a high profile case, so she was not a circuit judge for the district court of appeals. She was a personal lawyer. She didn't go to an elite law school, and so her nomination was withdrawn simply because, again, members of President Bush's own party weren't satisfied with that appointment. So a more traditional Samuel J. Alito was given to satisfy the conservatives who basically felt that Alito, passed the litmus test, whereas Harriet Miers didn't. Marital status. Again, that's the correct answer. I mean, does it have a bearing? I mean, does it help if a justice has been divorced like 5 times? Probably not. Maybe a little bit, but again, it has the least amount of bearing. Again, most of these justices are married, but again, it's the personal lives of the judges, because they're not really politicians. That definitely has less of a factor than someone running for president. If you're not married and you're running for president, again, the only precedent we have of that is James Buchanan. Then it becomes more of an issue. But as Supreme Court justice, the primary considerations, again, are party affiliation, judicial experience, philosophy, educational background. Again, general competence, basically. That's what the Senate is looking for. So they're really not going to pry too much into the personal affairs of a Supreme Court nominee. Again, unless it involves possibly something criminal. Clarence Thomas, he was eventually confirmed, but there was a lot of speculation on whether or not he sexually harassed a former employee, Anita Hill. So there's a lot of hearings that took place to deal with that matter. So yes, your personal life will be out in the spotlight, but again, marital status itself is not going to be a huge determinant on whether or not you're going to be serving on the Supreme Court. And the final example, which of the following terms best describes the Supreme Court's issuance of an order directing a lower court to send up its record for review? This one's really easy. It's going to be writ of certiorari. It's not going to be amicus curiae brief. That's going to be briefs written by interest groups. Filibuster is when a senator is trying to kill a bill on the floor. Rule of 4 is how the Supreme Court decides whether or not to hear a case. And cloture is a way to kill the filibuster. And again, that's more of a Senate procedure. So the correct answer is a writ of certiorari. Again, just because the Supreme Court actually hears a case and doesn't rule on it doesn't mean that they actually accept its ruling. It just simply means that they didn't rule on it. And again, this writ of certiorari means that they're going to request that the lower courts, bring the relevant documents so that the Supreme Court can review it. Thank you for watching educator.com.